morning, everybody. I'm Bruno Giancarelli, and thanks for being here quite early. I see that people are still coming in. Welcome to this panel. As you will see, this is a truly international panel, both here in the room and online. This panel is based on a key realization. Data protection authorities, data protection regulators around the world are increasingly enforcing convergent rules, often investigating similar commercial conducts, if not the same companies, and addressing similar challenges. At the same time, enforcement cooperation between privacy regulators is, to a certain extent, less developed than in other regulatory areas. I'm thinking about financial supervision, competition, or consumers. So the idea of our discussion this morning, of our conversation this morning, which, as you will see, brings together both well-established authorities that have been on the market for a long time and newly created ones. Our aim this morning is to identify opportunities, challenges, best practices in the area of cooperation between privacy regulators. In doing that, we will also explore the increasing role of network. There are today network of data protection authorities in almost all regions of the world. And that's also a very new phenomenon, that those networks play an increasing active role in organizing and in structuring enforcement cooperation, in developing compliance tools, be it in Latin America, in Africa, in the Asia-Pacific region, or in Europe. And to discuss that, I'm joined really, and I'm very pleased for that, I'm joined by a great group of speakers, as I said, both in the room and online, starting from Anne Debay, the Vice President of the French Data Protection Authority, the CNIL, Carly Kind, online, the recently appointed, and we want to congratulate her for that, the recently appointed Australian Privacy Commissioner, Arjuna Erat, next to me, the Commissioner of the Office of the Data Protection the Chairman of the Sri Lanka Personal Data Protection Authority, Immaculate Kasai, the Commissioner for Data Protection from Kenya, and finally, also recently appointed Green Thief de Jesus Sierra Caldena, the Deputy Superintendent and responsible for data protection in Colombia. So we will divide our discussion between now and I think 10 o'clock. I will be asking, we want this to be as much as possible a lively conversation amongst ourselves, amongst the speakers, and with the room. I will start by asking each of our speakers a sort of introductory question, and then we will take it from there, because I'm sure that already from those answers a number of interesting remarks and ideas will emerge. Maybe starting, and I hope everybody's connected. I'm saying that everybody's connected online. So first with Carly. Carly, as I said, first of all, congratulations and thanks for joining us from Australia. You have taken office in Australia earlier this year, and what we would like, or what I would like to know, is based on your recent experience, what opportunities do you see for cooperation between data protection authorities, both in the area of developing compliance tools or facilitating the development of compliance tools, or also in the area of cooperation, enforcement cooperation? Do you see, do you think there's enough of that cooperation? There should be more of that cooperation globally. What does it represent for you, your authority, and yourself as somebody who has recently joined to lead a privacy authority? I was told that the connection was working, but maybe I was too optimistic. We just lost it. Don't worry, we'll come back to Australia, but then let's go to Sri Lanka. At least Sri Lanka is here in presence physically. So, so I think, Arjuna, your position is on this issue also, and your point of observation is particularly interesting because you are in the process of building a new authority. And I think it would be interesting for us to know more about how do you engage in this sort of launching phase with regulators globally. What do you see as opportunities in this type of engagement? Do you have priorities as a newly created authority in engaging with both, I would say, bilaterally with authorities or with international networks of regulators to advance your work in this very important, as I said, launching phase? Thank you very much again for being here.
Thank you very much, Bruno, for inviting me and my colleague, Jayanta Fernando, who is architect of the legislation, is also here joining me. It's great to be here at this session, and thanks to the audience to be present here for a discussion that I'm looking forward to. Just to start, to give a context to answer your question, Bruno, the legislation in Sri Lanka was enacted in March 2022 after an extensive public consultation process from 2018 to 2022. And the Act came into being in March 2022, and the Act says that the Data Protection Authority, the regulator, will have to come into operation not less than 18 months from the enactment date and not later than 36 months. So as soon as the 18-month lapsed, the government appointed the board of directors.
Authorities, essentially the...
Go ahead. Go ahead.
As soon as the...
It's the start of the day. We are just testing many things. Don't worry. Go ahead.
Thank you. So as soon as the 18 months lapsed, the government appointed the board of directors. Now I must say, the initial mandate to the board is to set up and institutionalize the Data Protection Authority or the regulator. And this act is the first in South Asia of a Personal Data Protection Act. Is the first in South Asia. And it's a new sort of phase in our regulatory environment. We don't have many privacy experts. The context and experience of enforcing regulation on privacy is something that is recent to the country. So in this context, and also it's a greenfield project, so it was not an existing institution, or it was not set up within a government department. We were told, set it up brand new. The reason for that is the authority was to be very independent, and the board, in fact, consists of all private sector people, with the exception of one person from the public sector. So in this context, the challenge is that to create a regulator institution in the public sector environment within a period of 1.5 years, because we have to enforce the Act in March 2025. So that's in another 6 months. Creating the institution, recruiting the staff, building the skills and the capacity, and ensure that we are competent to enforce the Act in 1.5 years. We felt it was very challenging, but we have taken up the task of wanting to do that. So the opportunities here is that you have sort of, we don't bring in sort of baggage here. We have an independent board mindset to create a regulator that is smart and effective and efficient. So with that context and with the private sector orientation, we have started building the institution. But I must say it has been challenging to recruit staff because in a government environment, the public sector salaries and the private sector salaries, there's a big gap. And if you want to get good talent, we have to give higher scales, more than the public sector scales. And getting approval for that has been very challenging. But fingers crossed, we are expecting the approvals to come within the next few weeks for us to have decent scales to recruit talent. And I have been hearing in this conference the challenges that the regulators have of attracting and retaining talent. And that's in that context, you can imagine the task that we have in order to do that. So whilst we get to doing that, you were asking about collaboration, Bruno. So we didn't want to waste time in getting going with this because we will not be ready if we don't have sort of set up institutionalized very quickly. So the development agencies, the multilateral development agencies have come to our rescue. There's a lot of support in this area that's forthcoming, thanks to DG Just, who has been supporting us very actively with a strong support. We had World Bank, we have UNOPS, and we have USAID. All of these agencies are giving us support on various fields. So we had DG Just coming and their consultants helping us to formulate the strategic plan and the operationalization roadmap. So that's our framework for setting up. We have the World Bank supporting us to do the rules, regulations, and guidelines in the provisions in the Act. You have to set up our rules, regulations, and guidelines to enforce the Act. We are doing that at this moment, the board and the consultants together. UNOPS came and gave us local consultants to do the schemes of recruitment, the pay scales, the entire administrative setup. And then we have USAID, who is going to come and support us on the marketing and PR aspect of wanting to establish credibility for the institution. When we start enforcing it, there has to be a positive mindset across the stakeholders. So we are, at the moment, formulating the strategic plan, a marketing and a PR plan to ensure that. So a lot of work is happening, even without staff, and we are hoping within the next few weeks we'll have the staff on board to do our job. So our priorities in terms of next priorities is clearly the requirement to, when we recruit staff, to have the necessary competence and the skills built in the staff. And in that process, we are talking to our multilateral development agencies to try and get some support to develop the skills, knowledge, and the competencies that are required. That's the other thing. The second priority we have is to, once we develop the rules, regulations, and the guidelines, we have to go through a public consultation process to make sure the stakeholders buy into these rules, regulations, and guidelines, and the enforcement becomes easy. And that's our second priority. And this is a very critical element, we thought. We want to create a culture. We find that if you have to have a push strategy to enforce the Act, there's always tendency to people to undermine the Act, to work around the Act in order to manage, because it's a new area for us, and people have been doing their business as usual and will want to continue to do business as usual, and enforcing the Act will, in fact, bring about some pressure on them to how do you manage that. So the idea here is that try and create a culture of compliance as opposed to enforcing the Act and penalizing them. And we must say the Act provides to do this for us. The Act says the directors of boards of directors of companies will be personally liable for violations of the Act, and they penalties will be imposed on them. And this has got well established and entrenched in the minds of the private sector, and that has caused the boards to really proactively prepare themselves to comply with the Act. So we are hoping that a regulatory culture compliance will set in, and that will help us to really have an ecosystem that's got built of a kind of compliance culture in order to manage this whole enforcement. This Act is to be enforced across private sector and public sector. And while the private sector gets ready for it, the public sector is a challenge, right? They have this, public sector has a feeling that we are the government, so we'll manage this, right? And we are, in fact, very focused on wanting to make sure the public sector is as compliant as the private sector, and those are the big-time controllers. And we are building another institution to try and build capacity in the public sector to comply with the Act, and we have support from a multilateral lending agency, development agency, to build capacity in that institution to create capacity in the public sector to be compliant with the Act. Thank you very much.
No, thank you, and I think we will come back on certain of these points because those challenges have been faced by any authority that has been through the journey and continues, as you said, including in terms of recruiting and retaining talents to be faced. But I understand that Carly is back, is connected with us. So Carly, first of all, welcome and congratulations again for your appointment, for your recent appointment. My question to you, I think you heard actually the question. We didn't hear the answer, but you heard the question was, for you personally, rather new in this job, leading your authority, and for your authority, what does international cooperation mean in terms of opportunities? Where do you see it going in terms of developments when it comes to enforcement cooperation, when it comes to working with other authorities in maybe also in terms of developing compliance tools within bilaterally or within a network of regulators?
Thanks so much, Bruno. I won't keep talking until you confirm you can hear me this time.
Yes.
Have you got
me? Yes.
Great.
I'm sorry again for that.
Okay.
Sorry again for
not
that.
Your fault. Not your fault.
It's very good to have you and now to see you. It's even better. So the floor is yours.
Yeah, good. Thank you so much. And thank you again, Bruno, for the invitation. And it's really an honor to speak alongside these expert and experienced colleagues as the new kid on the block in the Data Protection Authority circuit. I have now been in the role of Australian Privacy Commissioner for 3 months, so it's still very new and very fresh. And I suppose my mission are still being
Okay.
I'm so sorry. I don't know if you can hear me again.
Yeah, we can hear you. We can hear you. We'll manage.
I'm so sorry. I feel terrible to be the source of technical glitches.
No.
I'll keep going unless you say otherwise, Bruno.
Go ahead.
Apologies. Okay, I'll talk faster perhaps. As I was saying, I'm relatively new in the role, so still forming views on the challenges to enforcement and cooperation, but bringing, I think, a perspective of having been in civil society for a very long time and wanting to see more of regulators now to be in the role of data protection regulator and to see the challenges of doing enforcement broadly has been very eye-opening to me. So I would say the first challenge around enforcement cooperation is a step before that, which is just the challenge of enforcement generally in the data protection space. And I think that different regulators have different regulatory frameworks, different legal environments, different or give rise to different experiences. In the Australian restraints on enforcement action writ large for Australian Data Protection Authority, in a very high-level summary, that would include the Act itself is out of date and needs reforming, and therefore doesn't, I would say, encapsulate the full range of privacy harms and threats that we might want to pursue as a regulator. Secondly, the mechanisms for enforcement create a very high bar for us to take enforcement action. That is, we have to establish that interferences with privacy have been serious and repeated. And we have no power to issue fines ourselves, but rather have to seek civil penalties through the court system. So those two things, and a third thing would be just resourcing, just pure numbers in terms of staff and dollars to enable enforcement action to happen. So I think those things generally are part of the landscape that we're facing, at least in Australia, when it comes to looking to enforce the Privacy Act. But having said that, I think that there is a lot of scope for enforcement cooperation in terms of strategic and tactical mechanisms to come, particularly at systemic privacy violations that, as we know, or as we all know, cross jurisdictions. I think my instinct at this stage is that a key to unlock regulatory collaboration and cooperation is the ability to think together strategically about how to leverage perhaps different frameworks, overlapping jurisdictions, or different nuances in different legislation to come after whole sectors where we can see kind of market change. And that, I suspect, but I'm very new in the role, so still finding my feet, I suspect comes chiefly through time and opportunity to talk with colleagues in different regulators about how we might, you know, put the jigsaw puzzles of our frameworks together to create coverage, to create opportunities for enforcement. And that time and opportunity is through international forum, is through conferences such as this, is through the Global Privacy Assembly's International Enforcement Working Group, is through regional groupings as well, the Asia Pacific Privacy Authorities Forum, for example. I think my instinct is it's through that very personal relationship building and time together to strategize that we will see effective regulatory cooperation emerging. I've already begun to scratch the surface of that, and in that respect, I'm very much building on relationships I already have with the ICO, for example, the opportunity just to throw around ideas together with people I know from previous roles, and I hope that I'll have the opportunity to build those conversations out, including with others around this table. So I think that's really a big key to unlocking regulatory cooperation. In terms of what regulatory cooperation might offer us in terms of affecting change, my preliminary view at this stage is that there is some virtue in us thinking about how to take complementary but not duplicative action. And one thing I can see has been explored in the past by my Australian colleagues is mirroring actions that have been taken in other jurisdictions. So, for example, we've been making inquiries around some of the enforcement actions that have been taken in the UK and Ireland with respect to TikTok and its use of children's data. There is, of course, and we can talk more about this if useful, the collaboration on Clearview AI that was undertaken by Australia, the UK, and Canada as well, wherein we've looked at the same set of activities, functions, the same privacy violations, but in jurisdictions, and seek to take kind of mirror action. And I think that that's one way of thinking about regulatory cooperation, but I'm very interested in thinking about how we might take complementary actions that perhaps come at some of practices from different directions, and seek to have, to really look at like market change. And this is something I think European regulators do very well. And I know there's a high degree of regulatory collaboration amongst European regulators, but really seeking to have complementary approaches is something I'm very interested in. And then the final thing I'll say, just while my internet's working, is we do have an excellent example of collaboration underway with the New Zealand Office of the Privacy Commissioner with respect to the Latitude group of companies that arose out of a large-scale data breach. So our New Zealand counterparts are looking at Latitude New Zealand, and we are looking at the parent company, Latitude, which is domiciled in Australia. And just without going into the details of the investigation, there is a very fluent collaboration between my colleagues and those of the New Zealand office, including fortnightly phone calls to facilitate the sharing of information. So I think we have some good models about how that collaboration can be done in a very practical way.
Thank you very much, Carly. I think you have...
I'll stop there.
Yep. Sorry, didn't want to interrupt you. Thank you. We will come back to you, but thank you very much, because I think you have identified the different dimensions of cooperation, from the very, very basic by sensor step of indeed creating relationship, exchanging information, knowledge, experience, to working together, as you said, mirroring action, also to complementary action that also raise, questions around how to develop mutual assistance. For instance, what you said about working together on parallel investigations or behavior. I mean, data breach is an excellent example because data breach often affects and impacts simultaneously several, if not many, jurisdictions. I think all those are essential aspects on which we will also come back first through this question and then our discussion, including with the room. Let's then move with our Kenyan and Colombian colleagues to another dimension, which is the role networks have. In Europe, we have, of course, the European Data Protection Board, but we are far from far to be the only region in the world that has structured its cooperation first regionally, but also our cooperation with our international partners through network. So that brings me to Immaculate. Immaculate, I hope you can hear us. You have just hosted in Kenya, in Nairobi, the meeting of the Regional Network of African DPA, the NADPA. In your view, what role can regional networks of DPA play in promoting this type of cooperation that Carly was referring to in those different dimensions? What role regional DPAs can play in promoting joint enforcement activities, for instance?
Thank you, Bruno. I hope you can hear me.
Yes, very well, very well. I think we need really to remove the video to avoid. I'm very sorry, Immaculate, but it's very good to see you. But I think that to avoid the type of problems, and this is on our side, sorry for that, to avoid the type of problems.
No, that's fine. That's okay. That's understandable. Thank you, Bruno, for the question. And it's good to see all the panelists there. I want to encourage to take it in a stride. We also New Kids on the Block just a few years ago. Having said that, thank you for the question, Bruno, on the areas of collaboration and what networks can do. I think they have a very significant role, and I just want to say it's interesting. Before I go, what would I consider as a priority for networks to network? I just want to lay a basis how ironical it is that we are speaking about an area of work that ordinarily should be the first thing in terms of collaboration. Because when you think about the trans-territorial, cross-territorial nature of data protection, when you think about the issues around the companies we have to deal with, they are mostly big tech. When you think about the platforms we have to rely on, they are hosted in different countries. When you think about that, I mean, it should be common sense that then collaboration becomes the first thing that we do. However, that is not the case. Many times, just to give our own example as Kenya, when we were dealing with issues around digital lenders, the platforms that digital lenders use is not a Kenyan platform. It's based in a different country. So when you write to the country, they then write back to you. They don't even write back to you because you don't have an existing mutual agreement. You don't have regulatory frameworks that govern these countries. So that already is a challenge. And given the fact that some of the issues we are dealing with cuts across, I think collaboration between data protection authorities and networks becomes a priority if we are going to make this a success. And also just to say, we've seen, and also consistency. Kenya being a member of the Commonwealth and the jurisdiction of law, we've seen, precedents. When a decision is made in any of the Commonwealth countries, it becomes binding on any other Commonwealth country. I think that's an excellent opportunity to then introduce the issue around networks. And we've seen European countries, the GDPR, do this very well. When it comes to the role of the network, the truth of the matter is an African Data Protection Authority, as a NADPA, they fall within one sphere. So they have commonalities, and nuisances are likely to be the same. And therefore, the issue of collaboration becomes critical. They can collaborate in terms of capacity. We have benefited from DJ Just in terms of when it comes to an investigation and we needed specific issues addressed. We had an expert coming through the European Union coming to help us. That's an opportunity right there for collaboration within the network of African Data Protection Authorities, because it's within the same geography. The second one is resources. Resources in terms of what already have some countries done. If a country has already come up with what we say regulatory framework, it's easy to help the others to come up with a regulatory framework. Two, the country has come up with standard operating procedure. It's easy for them to then work within the country, within the network, to then adopt a common standard operating procedures, so that when it comes to issues of procedure, it becomes easy to can apply across board. Three, when it comes to resources, what decisions have the network or members of the network made? For us, for instance, in our case, we've had almost 5,000 complaints with 3,000 closed, 106 determination and 60 enforcement and 9 penalties. That right there is a pool of resource available that can then inform other network members how, in terms of resourcing, they can address a concern. If we are able to share those resources, it means if you make a determination on a multinational or on an institution that actually covers beyond the jurisdiction of Kenya, then there's a consistency. Because the risk we run of not collaborating, and especially when it comes to enforcement, you will have determinations that are made with same set of facts, different set of decisions. Assuming that looks untidy, because then when you have that kind of interjection or that kind of inconsistency, then we are all running different worlds. Yet the bottom line is we should be human rights driven. Our true north should be the right of the data subject. So that is another area of collaboration. The other area of collaboration that I see in terms of this is sharing and I would also say the tools for the resources, is beginning to enter into some sort of agreements within networks. When we enter some sort of networks, we then begin forging a common platform together and agreeing on what are the minimum standards and how can we assist each other, what are the mutual agreements. And Bruno and my fellow panelists, this is not unique. We've seen collaboration when it comes to issues around terrorism. We've seen collaboration around counterfeits. We've seen collaboration around some of the international crimes like human trafficking. So what is stopping us from collaborating when it comes to data protection? Yet this is the biggest opportunity, yet also can be the biggest threat of our generation when it comes to identity theft, when it comes to cross-border crimes, when it comes to even trolling people on the internet. I think that there lies greater benefits in terms of collaboration than there lies disadvantages. I think I'll stop there for now.
Thank you very much. In very clearly identifying again some key opportunities and challenges. In particular, I've noted down what you said, that's of course a very clear benefits of such networks in terms of pooling resources with a clear economies of scale, of developing convergence and consistency. We often hear about risk of fragmentations, different approaches. And that, I think, is a perfect link to Grenfith and what the Ibero-American Network of Data Protection Authority has been done. This is clearly one of the most active network today, with really some tangible examples of what that cooperation can bring regionally, but also in helping a region building bridges with other regions in the world. And think about what the Ibero-American Network has been doing in terms of developing joint rules, joint compliance tools, such as, for instance, model clauses for transfers in Latin America, but also thinking about the cooperation that took place within the network, the Latin American or the Ibero-American network recently on artificial intelligence, and in particular around ChatGPT. So to your, from your point of view, could you tell us a bit more about that process of working with your regional counterparts and what it brings concretely to your authority? Thank you very much for being here with us today.
Thank you very much, Bruno, for your invitation here. It's very important for the Colombia Authority to be here. In the Colombia DP DPA. It's in particularly the authority because we have a long tradition administrative with the strong administrative decision. Also, we are a strong judicial review and have two levels, administrative level and judicial level. Colombia DPAs is a leader in the Latin America. We are activity members of the Ibero-American network at DPA. Today, within the privacy has no borders, national borders, traditional borders, so cooperation is the way to protection today that as a global challenger. Because today in the that antennas and good commands and the command world. To do so, we work with our partners to develop regional convergence. This is the case of the model clause of Latin America that we have approved. For us, it's very important have the coordination, administrative, the coordination, the harmonization, the normative, for have a strong authority for the big company. It's very, very important for us. Being here allow us to exchange views with our colleagues from the Union European. I repeat, it's very important because the challenger is the global. It's now the country challenger is the global challenger. So it's very important and administrative cooperation, IT and judicial review cooperation.
Thank you. Thank you very much. Finally, Anne, from your point of view, can you tell a bit more about the relevance of international work for the CNIL and in particular international cooperation? Are there concrete examples of investigations where the CNIL reached out, worked with its partners outside the EU? Of course, you work on a daily basis within the EDPB with your partners within the EU. That's our mechanism of co-decision within the EU, but of course, I'm sure there are also important examples of that international cooperation, what it has brought concretely to enforcement, to the effectiveness of your enforcement in France.
Yeah. Thank you, Bruno, and thank you for inviting me to present our international cooperation example. I will first start by not answering your question, just to have a quick a quick introduction about our cooperation in the European GDPR. Because we do, just to explain you, we do a lot of things with this regional cooperation. More than 1,000 cases were launched since the applicability of the GDPR in 2018. Some tools were developed by the EDPB, like the Common Enforcement Framework or the strategic cases. For example, we work together on the DPOs, challenges faced by the DPO, difficulties they can have. We're going to work on the right of access. I can give you concrete examples of cooperation, but that is not the subject. But what I wanted to point out is that we need to put a lot of our means in this European cooperation, and it's mandatory. Therefore, it's sometimes difficult to concentrate on international cooperation, and we're sorry because we'd like to do it more, and we cannot do as much as we we wishes to, and we face challenges in the European cooperation that we also have, but on the other scale, on a larger scale in the international cooperation. So the difficulties we have for the European cooperation, which you know of course, procedural or substantial, this means that we also have difficulties for international cooperation. So we try to strengthen links with the countries DPA who share the same values, and of course the adequate countries, and like the ICO, and the Commission does a lot of things in this field, and maybe you can talk about it, Bruno, if you want. And DPNID is currently strengthening the dialogue with the DPAs from Korea, the PIPC, and that's for adequate countries. Of course, we participate in all the forums that are well known, like the GPA, Global Privacy Assembly, and all the other OECD fora to discuss and to share information. But I would say that it's about sharing information, sharing good practices, but I wouldn't say it's concrete enforcement. We have to work to do really more concretely. And for non-adequate countries, in fact, when you asked me to be in this discussion, I didn't find many examples of concrete, many concrete examples of the international cooperation. I mean, real investigation. I can give you 2 examples. I can give you many examples about the European cooperation, but it's not the subject, of course. No. But we ask counterparts from Morocco once, because they are members of the Convention 108, to investigate a company located in Morocco that was targeting French pupils. And we also received requests from our colleagues from Senegal. And I think that's it. Why do we not do more things, real enforcement? I think that there are, of course, some legal challenges because cooperation on enforcement action requires transfer of personal data, and this must be safely. We have to be exemplary when we cooperate. So it means that we have to find which jurisdiction we can cooperate with, and we need to have tools to cooperate and to exchange data. So the EDPB issued a toolbox on essential data protection safeguards to exchange data. And the second challenge, I would say, is to develop tools to cooperate, really concrete tools. We have the Article 50s, GDPR, that would provide a framework for that, but in my knowledge, so maybe Bruno knows more about it, it's not really used. There has been some memorandum of understanding between countries, but it's, as I know, mostly informal, so it's not really concrete. And DPAs could develop themselves an administrative arrangement. It is what is set up in the Article 50. And the problem we have in France is that we have no legal capacity to do so. For example, so the PID has no legal capacity to conclude such international instruments, so that we cannot discuss directly. We need to go through states and our government to do so. And that's the case also in many fora. Even the Convention 108 plus might be a good tool, because when it will enter force, we are in the in-between stage right now, which is quite complicated, because the Article 17 of the Convention sets up for a cooperation between DPAs. But even in the Convention 108 plus, for example, in the Convention 108, the consultative committee is composed of members representing by the governments. We have an agreement with the governments, and we go to the meetings of the consultative committee, and I'm sure we'll go to the meeting of the convention committee that it would be set up in Convention Summit. But we have this problem that, and also in the OECD, that we are not the one who are collaborating, but the states are. So that's one main challenge that we have to face. Thank you.
Thank you very much, Anne, for laying out so clearly both the benefits, but at the same time the limitations, and the potential also for cooperation. What you said, I think, is very true. And that's what I was trying also to mention at the beginning of this panel, that it is quite surprising, if not shocking, that we meet a lot on international cooperation. there's clearly, as we've heard also today, authorities are essentially looking at the same things and developing similar tools and investing similar commercial behavior and often the similar companies, but that some basic tools are missing, which explains why cooperation in the area of privacy is real cooperation, cooperation on the ground, cooperation on cases, on investigation is underdeveloped compared to other regulatory areas where those tools in terms of mutual assistance, in terms of requesting other authorities to carry out some investigatory measures, where those tools exist. It's interesting what you've said, and this is something we also feel, that in a certain sense, privacy or data protection and the lack of tools between regulators is an obstacle to cooperation on privacy and data protection. Indeed, we have in the EU, we believe, a powerful article provision in the GDPR, Article 50, that we want to use more. Certainly, as Commission, we will ask our member states to give us a mandate to negotiate enforcement cooperation agreements with partners, key partners. This is in a certain sense to bring international cooperation to the next level. We need binding tools as they exist in competition, in financial supervision, in consumers. And we will ask, actually, we will work with the European Data Protection Board to ask, what are those countries with which we are working the most in terms of or where you see there's a need for cooperation. Networks, and maybe it's also a way to go back to what Immaculate has said, networks can, in a certain sense, fill that gap because they organize cooperation regionally, but there's by structuring cooperation regionally, they also facilitate cooperation with other networks. I know that in the coming month there will be, and this is I think a very important development, there will be for the first time, organized by our Moroccan friends, the first meeting of networks. Again, to try to bring this forward. So maybe, Immaculate, going back to you and then seeing also if there are questions from the room. You have had recently, very recently, 2 weeks ago, if I remember well, the meeting of the African Network of Data Protection Authorities. Anything you can tell us about some concrete actions that have been decided there or some priorities that have been established or announced for your work amongst members of the African Network?
Thank you. Thank you, Bruno. Concrete, not concrete resolutions, maybe emerging issues from the conference. One, which is critical and has been mentioned here, is the issue around regulatory framework. Because one of the biggest challenges is the lack of fragmented regulatory framework within the region and the need to work towards harmonization. The other key issue is within the region to begin discussing issues around adequacy. Because adequacy decision, apart from addressing data flows, would also give an opportunity for cooperation on other aspects. The other issue that came up very, very strongly is for the network to take a more robust role in being the visibility in as far as the work of the network is concerned. And I'm glad you've mentioned the issue around Morocco hosting the network, which I think they are hoping to have it later in the year. And that is one of the things that is being spoken about in terms of how do we move this conversation forward, whether it's harmonization of law, whether it's cooperation, whether it's adequacy, whether it's capacity building. Those are some of the emerging issues that were underscored. I think people, members now begin to appreciate the more that there's strength in numbers, there's strength in cooperation, there's strength in working as networks, because then that way you have an opportunity to not only share an opportunity. And just to speak to that, one of the things that we'll be speaking, because I'm at an ID for Africa conference in South Africa. Tomorrow, one of the things that we will be sitting on a panel to discuss is how data protection authorities in their different capacity are shaping that conversation. So this continuous conversation around regional and global platform is not only strengthening network, but also making people realize the importance that network can play in as far as cooperation is concerned.
Yes, and thank you for those, for this additional information. First, indeed, our Moroccan friends have called. I think it will take place after the summer for the first meeting between networks. So that network-to-network cooperation is a very interesting development, also in terms of critical mass of authorities. What I think our discussion also shows is that there have been a lot of convergence in terms of substantive data protection laws. When we look at, meaning here we have representative of all continents, from Asia Pacific to Latin America, Europe, and beyond. And if we look at our laws, we see that on the essential, on the fundamentals, our laws are very well aligned. And that actually, when we are interpreting and enforcing those principles and requirements, we're looking essentially at the same things. But that convergence has not yet happened, has not yet taken place when it comes to the more, I would say, procedural aspects that are so essential because they are part of also the solidity of and the legal certainty of cooperation and investigation. This is something we were confronted, and we are confronted, first of all, in Europe. We are about to celebrate tomorrow, actually, the 6th anniversary of the GDPR. With the GDPR, we have harmonized in Europe, to a very large degree, substantive data protection laws, but because it was not possible at that time, we have left the procedural aspects outside of that, or we have really not concentrated to the extent maybe we should have on the procedural aspects. And that's why last year we have come with a new proposal to complement the GDPR. I think these problems we are facing in Europe is a problem which is to a certain extent shared by our international partners. So I'm looking, before turning to the room, I'm looking at the other panelists. If Carly, you, Arjuna, or you, Greenfield, would you want to react to anything you've heard?
Thanks, Bruno. I'll come in really quickly, and I hope that you can hear me. Just to
yes,
say that
well.
what Anne said about...
you see, it's improving by the second, so we should be optimistic about this day. So
good.
Go ahead.
Good. It must be a metaphor for the improving nature of authority collaboration by the second. But just to say what Anne said about the technicalities of cooperation really resonates as well with me in terms of we do use MOUs. I don't think we have the same kind of legal constraints that Anne spoke about, but the secrecy provisions of our legislation are broadly drawn, and there is some risk in pushing out the boundaries of those secrecy provisions that I think can be mitigated and embraced even, but it's a change in approach perhaps, and a change in culture that would need to happen to enable that. So I do think there are some very technical barriers and that we need to work to overcome. And then I think that, Anne's point also about information sharing, I mean, the Asia Pacific Privacy Authorities Forum seems an excellent example of really strong information sharing. There are, as far as I've seen so far, at least biannual meetings.
Yes.
At least one of those is in person. I had the pleasure of attending one last year. It was just very, very valuable. But taking it from the level of information sharing up to the level of enforcement cooperation is a huge gap, and it's a huge lift as well. And I think lots of things have to happen in order for that to occur. And ultimately, much of that will come back to, do we have the resource to make that happen? It seems to me it requires kind of dedicated work, dedicated people within your organization just to think about how to collaborate externally and to actively try to link up investigations and look for opportunities to work together. So yes, all of which is to say, I think the intention is there. I think the clear benefit of more collaboration, certainly it's clear to me, and it will fall to a question of technical barriers and then resourcing, how to resource it properly.
Yes, I cannot share more and agree more with what you said. Indeed, I'm taking note, huge gap, huge lift. Those technicalities matter actually a lot, because when you work on a case, the last thing you want is that if you exchange information, if you exchange evidence, etc., the last thing you want is not to be able to use that information or that evidence, or even that your investigation is then questioned and challenged because you have not used the right tools. That's why in Europe, certainly, and I think we share that with many partners, we want now to bring that cooperation to the next level by putting in place binding instruments for enforcement cooperation in particular on individual cases, because indeed a lot of these MOUs exist. They are very useful tool for that sort of trust-building part of cooperation, secondment of personnel, exchange of information on activities, major trends, but they are of no use or very limited use when it is about cooperating on a specific investigation. And that's really a gap that we need to address and to fill. But Arjuna, you wanted to add something?
No, thank you. We see there's an opportunity for us to strongly collaborate, because we are a brand new regulator, and we shape it the way we think is best for everyone and for our stakeholders. Our Act, in fact, enables, I just want to read this because I think to provide the context. The Act says, and whereas it has become necessary to improve interoperability among personal data protection frameworks, as well as to strengthen the cross-border cooperation among personal data protection enforcement authorities. And it goes on to say, and whereas it has become necessary for government of Sri Lanka to provide for a legal framework, to provide for mechanisms for the protection of personal data of data subjects, ensuring consumer trust and safeguarding privacy, while respecting domestic written laws and applicable international legal instruments. Now, what I wanted to say here is that also one of the preambles to the Act says that we have to create an ecosystem for economic development and progress and growth. And that's this entire Act is done in a manner to enable, to build trust and confidence and to create an enabling environment for progress. Now, we, in terms of cooperation, so we have a lot of cooperation now forthcoming to us, and we're looking at secondments of our staff to other DPAs, having mature DPAs providing us people to come and, handhold us in our journey. And we're looking at getting best practices to resource, and linking best practices to the tools and so on and so forth. So whilst we see this entire cooperation being very strong for us to sort of develop ourselves, but we also see another aspect that goes into laws of every country, the decision, the adequacy decision. And I'm just wondering, so all jurisdictions are now embedding this concept of adequacy decision, and our laws has that. We have to recognize another jurisdiction for able to be offshore, keep data, let's say. And this framework, I'm just wondering whether it's creating a sort of a barrier for effective enforcement, is something that we want to sort of explore. But I am seeing a scenario where, you're talking about tools, you're talking about procedural aspects of convergence of procedural aspects. Whilst we develop our data protection authority, I'm sure we will get to these tools and procedural aspects that are possibly best practices. And I'm just wondering whether there is an opportunity to standardize the tools and the best practices, the procedural aspects across jurisdictions, which gives comfort to data protection authorities across the world to collaborate more effectively for enforcement. And whilst I say that, I don't see that happening, because these adequacy decisions are causing tensions to try and recognize various jurisdictions for being able to, attract trade and investment. So I just want to leave that thought and see how do we really progress on that front going forward, while we have a lot of support. an enforcement area, I think there is, as you said, there is a lot of room for improvement. And how do we really get to mechanisms for better enforcement cooperation is something that we will have to work on.
Very briefly, maybe as a moderator should not answer a question, but I will turn to the room immediately. But very briefly on this, I think that those are tools that have not yet been probably sufficiently used. But when, of course, we put in place tools for the transfer and the sharing of data that ensure that continuity of protection, that should actually facilitate cooperation. Because as Anne was saying, I think you mentioned, Anne, the word exemplary. Meaning data protection authorities, of course, when they change data in the context of an investigation, have to comply with their own requirements for data protection. It would be almost paradoxical if this was not the case. So having adequacy decisions or other tools for transfer is, I think, an enormous enabler for that type of cooperation. Not sufficiently, the paradox is that this is not sufficiently used and maybe understood by who should be directly the one that are the beneficiary of those decisions. And that's why we want to complement those tools with the type of instruments in terms of mutual assistance, of joint investigation. And maybe indeed there's a need here to develop a sort of model agreement for this type of joint investigation, again, mutual assistance measures, investigatory measures. That's certainly something on which we are working. But that said, I think we have spoken, I certainly have already gone beyond my role as a moderator, so I will turn to the room to see if there are questions from the room on any. Yes, please, and if you could identify yourself briefly, that would also. And I think we even have a microphone. I said we're improving.
Good morning, Christos Velasco. They have a very cooperative state university adjunct professor in Germany, in Mannheim, also a consultant on data privacy. Interesting views to see, well, how the cooperation might evolve. I can see that there are some challenges still ahead. We have the OECD, the Global Privacy Law Enforcement Network, which is still, ongoing. And well, here in Europe, we have a number of other instruments that you might be much more familiar than I am. But my question to you is, how do you see the cooperation evolving from the national data protection agencies from different regions around the world when it comes to a data breach? Article 32 of the GDPR, but a data breach also has some cybersecurity ramifications and implications here in Europe. That there's also the need to notify, the cybersecurity authorities and the data controllers whose personal information has been breached. So my questions to you is there a concrete example of how this cooperation has really flow and evolve in this particular area of data breach? And if not, how do you see that evolving in the near future in all these different regions that you are representing, taking into consideration that it has this cybersecurity implication and ramification? Thank you.
Thank you very much for this question, which is very interesting because it raises two dimensions of cooperation. Cooperation between privacy authorities that might have to, that often when there's a data breach, face consequences of the data breach in multiple jurisdictions, but also cooperation between different regulatory authorities, not only privacy authorities, that are involved in some aspects of the data breach. Maybe, Carly, you mentioned that you are or you have recently worked with your colleagues in New Zealand on a data breach. Would you like to address that question? And I'm sure maybe Anne or others may want to add something. Was I too optimistic?
I can.
Okay, Anne.
Okay.
You can start.
I think data breaches are a very good subject to work on, because to improve cooperation at an international level, we need to have common rules. We need to have issue that there is no discussion on, and I think data breaches is an international issue where we can have an agreement. On data breaches, I don't know about the recent thing that the Australian authority did, but on the Ashley Madison case in 2015, I don't know if you remember, I think the Australian authority cooperated with the Canadian authority and also with the FTC. So I don't have any example of French cooperation to mention on data breaches, but I think that's really a good example where we should do things. As I told it earlier, the difficulty for us is that that's the member states that are usually, I mean, that are concerned with the international convention and not the DPA. But that's a point where we could all work together, I think, because it's easy. It's not like I think we had on Clearview AI. Clearly, we had difficulties to have a common approach with our American counterparts on this issue. So that's a good example where we couldn't get anywhere because, as I discussed, I think with Aaron yesterday, I think on web scrapping there is different approaches in France and in the US, or in Europe and in the US, I think. So if we need to promote international cooperation, I think we need to do it on really concrete and cases where we all agree. And I think on data breaches, there's no differences, or maybe there are, and that you know, and you can explain on the cybersecurity. I'm sure that there are different requirements, but I think we all agree on this, that it's clear that it's easy. Maybe children protection would be easy too, except that we'll see that age verification is an issue in itself. But we need to, I think we need to get together through the networks and find some strategic cases, or some cases where we have common rules and we need to work on. So I don't know what we could, I mean, I don't know how we could do it, but I think that's really a good example of what we can work on.
Yes, and it's
Can
interesting.
you hear me now, Bruno?
Carly, go ahead.
Yeah, sorry, thank you, apologies. I'm what a nightmare with this technology, but just to come in to follow up on Anne's contribution, a couple of reflections on our experience in this regard. And interestingly, I just gave evidence today to a parliamentary committee here in Australia that's looking at cybercrime and cybersecurity, and there's a big challenge wherein entities who are subject to data breaches have both obligations to report the data breach to us as the privacy regulator, but then also there's a lot of incentives and need for them to report it to the relevant intelligence organizations and law enforcement. And there's a bit of a tension there about whether they should have safe harbor to report information to law enforcement to facilitate the remediation of cyber security data breaches, which might be at odds with their desire to be very full and frank around a data breach that might lead to enforcement action from the regulator. So I don't know if that challenge is experienced by other DPAs. It'd be interesting to hear, but even within our jurisdiction, there is a tension there on data breaches, particularly in terms of different regulatory and government authorities wanting access to information for different purposes and how an entity might respond to that. To your point, to your question specifically, Bruno, on the collaboration with New Zealand on Latitude, indeed, that is a data breach related joint investigation. And I agree with Anne's instinct that it is a good aspect of privacy enforcement to collaborate on, because there is much in the way of common understanding around reasonable security measures. We are always referring to the international standards, whether they be NIST or ISO or other standards that should be in place. So there's a lot of, it's a very fertile area that we could find some convergence on, even if our regulatory frameworks diverge. The only thing to remark there is that depending on the legal regime, there may be different evidentiary thresholds that need to be met by different regulators that makes those collaborations slightly more difficult. And I would observe finally that the evidentiary burden in data breach cases is a very, as far as I can see so far, a very complicated and high one, as opposed to other privacy infringements, which might be more legalistic in nature. There is a big challenge around documenting the evidentiary aspects of data breach and cybersecurity related interferences in my experience so far.
Thank you very much, Carly. That was very interesting. I'm very happy that we managed to reconnect you on this. Any other reaction on the table on this? It resonates a lot also from our side, because it's interesting that we had, maybe some of you know it, in March, the first meeting where we gathered for the first time all the countries with which we have an adequacy decision to really, again, sort of show the network effect that can have. And one of the issues that, and they were represented both by the regulators and the government, and one, in terms of cooperation, one of the area where everybody, and we're talking about 50, 16 jurisdictions of different sizes, different regions of the world, yes, we needed that on top of everything. Where an area which was identified as an area where there's which is seen as a, despite all the challenges that have been mentioned, but a sort of low-hanging fruit in terms of cooperation, because it's quite a straightforward area, was precisely data breach and large data breaches. And we're meeting next week to further explore that. Any other question from the room? No? Okay. Any final remarks from here? Any reactions from your side?
No, I think it's very important thing for the governance model. I think it's on response, global, possibility in their coordination, the authorities, to start investigation together for the big problem, big case. I think it's necessary in the niveau regional, not the national niveau. I think it's necessary building a regional administrative office to coordination, work in regional impact on decisions.
Yes, indeed. Thank you very much. So I think we can close. We are actually on time, which is also great. Very interesting, because on the one hand, I think everybody has stressed and from very different perspectives, newly created DPAs, DPAs that have been there for some time, a different region of the world. Everybody has noticed and stressed, I think, the need for cooperation, the many advantages of cooperation. And again, cooperation not in general blah, blah, blah terms, but cooperation on the ground. But at the same time, the need for specific tools in this area, role that networks can play. I think those are indeed very, very, very important issues. And also something that we certainly, from the European side, but I believe in close cooperation with our partners, will focus in the coming years, because that's really an element which is missing in the landscape. And in a certain way, as we all notice, also it's almost a paradox that on data, somebody has said, data no borders, and at the same time, our data protection authorities are not equipped to cooperate on, in particular, on individual cases. There's a paradox there that needs to be addressed. Thank you very much again. Thank you to you, Anne, Carly, Arjuna, Immaculée, and Wilfried for being with us today. Thank you for those who were connected and that had the patience to go through all these small technical problems we had, but which didn't prevent us at the end to have a collective discussion, conversation, and reflection on those important matters. Thank you very much, and have a nice day.